We are gathered here today to discuss the Affordable Care Act, a law with monumental impact in California, which has one of the largest populations of uninsured legal residents in the entire nation. What we want to do is offer up a safe space, a space that is safe from a lot of the political and partisan bickering that has surrounded this new health law, and make sure that communities have the opportunity to think about informed choices and informed decisions on the future of the health of this nation. And that's why we had this open dialogue, bipartisan forum, in order to provide both opponents and supporters of the ACA with equal time and equal footing to make their arguments before a 9-judge panel.
So here's the outline of the program. First, the petitioner, Ms. Sullivan, will argue for 29 minutes, 3 of which are uninterrupted. Then the members of our Supreme Court will have an opportunity to ask questions just as rapidly and as strongly as they choose. Then the respondent, Mr. Boutros, will testify for 34 minutes, 3 of which are uninterrupted. And finally, Ms. Sullivan will have 5 minutes for rebuttal. Ms. Sullivan, you have the floor.
Madam Chief Justice, and may it please the Court, when Congress enacted the Affordable Care Act, it brought an end to a problem in our nation's economy, the problem that 50 million Americans lacked health insurance, which did not mean they did not consume health care services. What it meant before the act was passed, that of those 50 million Americans without health insurance, 55 to 80% of them still consumed health care services, but paid for only 37% of those services. What happened? The cost of health care was shifted to other individuals in the market for health care, backed by health insurance, and their premiums went up. Before the act, it could be said that uninsured persons who consumed health care services shifted costs of about $1,000 a year in premiums to other Americans who footed the bill. How did Congress solve this? Through a comprehensive regulatory scheme, of which the minimum essential coverage provision, which is an issue before you today, is an essential part. Now, to describe the scheme to you, we've got to remember what Congress did that my friends on the other side do not contest was constitutional. The other side concedes that Congress could make insurers grant insurance to those people they previously excluded on the ground of pre-existing conditions. The guaranteed issue provision says that insurers may no longer turn away people just because they recently became ill or had a history of heart problems or a recent pregnancy. And in the community rating provision, which my opponents also concede is constitutional, Congress said that insurers who sell insurance in the interstate market could not charge higher premiums for those individuals with pre-existing conditions. Now, if you concede that the guaranteed issue provision is constitutional as within the Commerce power, you have to sell health insurance to people that might have been denied it before, and if you concede that the community rating provision is constitutional, insurers can't charge more to people with pre-existing conditions, then the third part falls into place as an essential piece of the Commerce regulatory puzzle. Minimum essential coverage is essential to the rest of the scheme. Only if you ensure that people take health insurance before they get sick, before they're on the way to the hospital in the ambulance, only if you ensure that you spread risk to people in time, before health crises befall them when we never know when they may or how bad they'll be. Healthcare is unique in the timing, frequency, and magnitude of the need of the consumer. Unless you have mandatory minimum coverage, the other two provisions won't work. And how did Congress know that? Because as Justice Brandeis said, the states are laboratories of experiment. And we had the experiment in the states. And 7 states tried community rating and guaranteed issue without minimum essential coverage. In other words, tried requiring insurance to be given without requiring everyone to buy it, and they failed.
Counsel, would you articulate precisely what activity it is that Congress thinks it's regulating?
The purchase of health care services is being regulated in advance. So all that this is a dispute about is the timing of the purchase of health care services.
It's a mandate, isn't it? It's a mandate.
You know, Your Honor, two answers. First, no individual is forced to buy health insurance. Remember, there are two choices here. The Act provides either that the individual buy health insurance or pay a tax penalty. One can forego entering into a private contract for health insurance if one is willing to pay the IRS at tax time a penalty that is capped at the amount of insurance you would have had to buy. So technically, nobody's forced into the market. But, Your Honor...
that doesn't sound like a real choice. They're between a rock and a hard place.
Well, Your Honor, nobody would dispute that Congress could impose a tax on all Americans to pay for a socialist version of health care and could rebate the tax to those who get their own insurance. Nobody would dispute that that's valid under both the commerce and the taxing power. The only difference here is that Congress chose to follow the American capitalist tradition of allowing the private market for health care and health insurance to prevail.
I want to step back on the capitalist tradition. The question that the Chief Justice asked you, you said the market is for health care services. But when you were describing the ACA, you talked about insurance. All of the other elements, the other two essential elements, are basically about health insurance. Why isn't health insurance the market that we're talking about here?
Justice Science, the answer is that healthcare distribution and healthcare insurance are part of one market. Congress is entitled to define them as one market. Nobody buys healthcare insurance to hang the beautiful insurance certificate on the wall of their living room. It is not a thing you purchase in and of itself. It is something you purchase solely for the ability to finance and prepare for the risk of your purchase of healthcare services themselves. And just as Congress was permitted in Wickard against Filburn in 1942 to define the wheat market as including both wheat sold interstate by commercial farmers and wheat grown at home, so Congress was entitled to define as one single market healthcare services financed by healthcare insurance.
But in the Wickard case, they were not compelling Wickard to buy anything.
Your Honor, in fact, the effect of the Wickard decision, which of course was the decision that held that Congress in the Agricultural Adjustment Act could limit the amount of homegrown wheat that a farmer could grow even to feed his own family, to bake pies and feed his own pigs. Now that sounds a lot like interfering with a local activity like the challenge here, and yet Congress was held permitted to force Mr. Filburn, in effect, into the market.
That may be true, but nonetheless, Mr. Filburn in the Wickard case was not required to buy wheat. There were other options. He could have lived with the wheat that he was entitled to grow in the 11 acres or whatever was permitted to him. In addition, he was actually in the production business. What we're talking about here is Congress exercising its powers on individuals, telling them that they from birth until death must buy insurance that many of them do not want to buy. Is there any other circumstance you're aware of where Congress has exercised a power like that to instruct individuals, not in commerce, to buy a product?
No, Your Honor, but just because it's the first time that Congress has enacted a mandate in this particular form does not mean it's not within the commerce power. And just to Mr. Filburn for a moment, in effect, Mr. Filburn was forced into the market if he wanted to buy the same amount of wheat. If he abided by the ceiling on what he could grow and consume at home, he was forced into the market. And that's why you said in 1942 that the statute under review restricted the amount which may be produced for market and the extent as well as to which one may forestall resort to the market. So it's not just that forestall resort to the market. Congress was allowed to forestall resort to the market. And the point about Filburn is that if he wanted to buy the same amount of wheat, he had to go to market. Similarly here, if you want to consume health services, you have to buy insurance.
Well, excuse me, but if we accept your argument, does that mean that Congress can mandate, for example, that people must buy life insurance, funeral insurance? All kinds of other risks can materialize unexpectedly, and the failure to buy insurance by some raises the costs for others, right? Those costs get displaced, the widow who is left without life insurance, for example. So where would we draw the line on this kind of coercive requirement to enter the market?
Yes, Justice Moran, and we accept that the commerce power is an enumerated power, it's a limited power, and there are outer boundaries to it. And we accept as well that there needs to be a tangible link to commerce. There has to be an empirical demonstration that this regulation is important to interstate commerce.
What would be the link? As Justice Moran points out, what happens if, for example, I'm from Florida. We have hurricanes. You're from California. You have a lot more. The Midwest has tornadoes. New Orleans, we saw floods. You have earthquakes, brush fires, mudslides. I think if you had frogs and locusts, you'd have all the plagues covered. So what happens if Congress says, you know, we spend so much money in disaster relief every year that has to be passed on to all of the citizens, all the individuals in the country. Why don't we just require that everybody buy disaster insurance? It would just be from birth to death, everybody pays a premium. They have to have disaster insurance. If it's a tornado, a hurricane, pestilence, it doesn't matter. They're covered. Could they do the same thing with that?
We do not argue that all insurance purchases could be permissibly compelled by Congress. And let me say what's different about this insurance market and those insurance markets. We require health care to be given when people arrive at the emergency rooms of our nation. We do so out of long-standing societal norms of compassion, but more important, we do so under mandate of federal law. The Emergency Medical Treatment Act requires that if you show up in an ambulance at an emergency room, you must be given care.
Does that mean Congress could pass a law that says we mandate disaster relief and then be able to exercise this power with respect to the purchase of disaster insurance? Because that puts it back in Congress's power to achieve the mandate by simply, you know, legislating another mandate.
Yes, in fact, that would be exactly here. I would like to say that the empirical demonstration of the tangible link, I want to refer the court to this very important brief submitted by the California Endowment, the leading supporter of health care for all in the state of California. And in there you'll see the exact limiting principle, that the problem here is created by a market in which there is an adverse selection and a free rider problem. Let me explain what I mean by those. The problem with health care is the suppliers have to supply it. They're bound by law. Other markets do not have that requirement. That means the treatment has to be given, the costs therefore have to be shifted to other people. Who signs up for insurance? If you allow people to just pick their own time to sign up for insurance, people will buy it only when they're sick. And healthy people who want to roll the dice don't buy it. So the cost isn't being spread among the folks.
I'm sorry, go ahead. Congress has gone much farther than just requiring people to get insurance to cover their EMTALA care, their emergency care. We've now mandated that they get care to cover a whole range of conditions. So it seems like the cost shifting from EMTALA really is not addressed by the law itself. It's not precisely addressed, right?
Well, Congress doesn't need to precisely address it. What you need to find to uphold this law is simply that Congress had a rational basis to find that there were market failures that would be cured by this law, not necessarily completely, but in large part.
May I ask just one other question about that? How should we think about whether Congress really did have a rational basis to conclude this? As I understand it, there's significant disagreement over this cost-shifting issue, the magnitude, how much really is going to be addressed at all by the law. How should we evaluate what Congress did, whether it fits tightly enough to let it go?
The answer to that question is that you need not show a perfect fit. Congress need not show a perfect fit, that there was no other way to achieve it. There might have been other ways. Some people think a single-payer system might have been better. But Congress isn't required to pick a command and control system over a system that tries to take existing private markets and make them function better. So a pretty good fit.
Hasn't the Congress already forced all Americans to buy health insurance by requiring every wage earner to contribute to Medicare? What if I want my own private health insurance? What if I want a better health insurance? I still have to contribute to health care. For that matter, I still have to contribute to Social Security. So hasn't Congress already decided the issue that it can require Americans to purchase health insurance as long as they can get to 65?
Yes, Justice Davis. And that helps me to show why, if you don't uphold this law under the commerce power, you should alternatively uphold it under the taxing power. And you've just described why.
I'm sorry, I thought you said at the beginning that this law could have been passed under the tax power. I assume you conceded it wasn't.
Not at all, Your Honor. I think it's an entirely separate, independently sufficient ground to uphold this under the taxing power. Congress is not bound to label its laws according to constitutional provisions. The idea that this is a tax, let me just go back to Justice Davis's question for a moment. It's undisputed that Congress has the power to tax all Americans to pay into Medicare. And if we stopped there, nobody would be here arguing about the commerce power. The question is, may Congress also in effect, tax everyone the amount it would cost to fund a universal health care system, and in effect give a credit to those who buy their own health insurance. Surely you can't strike down a statute merely because Congress didn't go through the kabuki dance of going step by step into enacting the tax and then issuing the credit.
Counsel,
This is
But respondents say this is not a tax. They say that it is a penalty for an unconstitutional mandate. So how do we distinguish between a tax and a penalty?
Well, Justice Moran, it's undisputed here that if what Congress had said was simply, if you don't get your minimum essential coverage from a private insurer or the new insurance exchanges that are created to give affordable health care to people who don't have employer plans, if Congress had said if you don't get your insurance from private sources, you must pay the IRS your amount for health care, it would be legitimate under the taxing power. So the only issue is, does the word penalty change that?
There were probably political considerations as to why it wasn't formulated that way.
Justice Moreno, that's exactly right. But Congress is not required to tell people that it's passing a tax. Here it gave lots of clues that it was passing the equivalent of a tax. It put enforcement in the hands of the Internal Revenue Service.
That actually is the opposite. I mean, what you're saying to us is Congress, who does not apparently have the backbone in the scenario to stand up and say, we're going to tax in order to provide health care to everybody who needs it, draws up a statute that appears unconstitutional under the Commerce Clause or the Necessary and Proper Clause, and then depends on the Supreme Court to figure out a way that it is constitutional. So we're supposed to look at it and say, okay, they didn't label it a tax, but maybe it's a tax anyway. So let's look at whether it's a tax or not. Taxes typically are for revenue raising. There's certainly, the independent mandate does not raise any revenue for the government, so I assume we're falling back on the penalty part that requires a payment to be made through the IRS in the event that the individual mandate is not purchased.
That's right, Justice Freer, but that does raise revenue for the government, and you long since abandoned any distinction between regulatory and revenue reasons for a tax.
So how come in the Act itself, when they listed with exhaustion every possible revenue source, clearly so that Congress could show this is not going to be as expensive an act as people think it's going to be. Look at all this revenue that's coming in. The one thing that is notably absent as a revenue source is the penalty that you now claim is a tax, a source of revenue.
And how is it a tax if you can't throw people in jail for not paying it, right?
Well, a tax...
If you don't pay your minimum coverage requirement fine, the IRS is prohibited from putting you in jail.
Or putting a lien on your property.
Or putting a lien on your property. How is that a tax?
The tax here is the penalty, which is a surrogate for paying your private insurance, and that revenue can be used from general funds to pay for any government expenditures that result from the lack of adequate health care for everybody. In fact, a lot of the rest of the bill expands Medicaid coverage for the poor in order to make sure that people who are poor can be covered. That's a government expenditure. But you don't need to get to the tax. You're getting to our alternative argument. I'd like to come back, and I want to make sure...
because I want to ask something that kind of goes to commerce and also maybe even necessary and proper, if that's another power that you want to put on the table. But I thought I heard you agree that there's never really been a law that operates exactly like this, in the sense that it under payment of a penalty requires a commercial purchase. Two things. One, in other federalism cases like New York versus United States and Prince, the novelty of the law and the fact that it was requiring states to affirmatively do things under pain of penalty, even though they weren't creating a problem other than the fact that they were existing, led us to be very skeptical of those statutes. But more generally, I just want to know, what is your best case? What is the case or cases in the U.S. reports that most supports your opinion, or are we writing on an entirely clean slate?
The best case is Gonzalez against Raich, in which you held that Angel Raich, even though she had terminal cancer and was palliated by homegrown marijuana legal to consume in the state of California, could be regulated by federal drug laws, because regulating homegrown marijuana was an integral part.
But growing and possessing and distributing and selling marijuana are all activities. As broad as Raich was, the Controlled Substances Act, like the Agricultural Adjustment Act in Wickard, which prohibited the cultivation of wheat in excess of the acreage allotment, all of those technically and formally regulated activity. Even possession is activity.
Justice Amar, the 1793 Webster's Dictionary defined to regulate, which is the operative verb in the Commerce Clause, as to prescribe or direct, as well as to proscribe or limit. There is no difference in regulatory power between making somebody do something in a market and keeping somebody from doing something in the
I'm
market.
not sure
case
that
to
the
tell that,
holders
right?
of the health insurance think that, because they're being told, they're being mandated by the federal government to purchase something that is in a very traditional state area in two ways: the reserved police powers and insurance law, both very traditionally.
But, Your Honor, you've long since recognized that insurance is an interstate market regulable by Congress, and in distinction to the New York and Prince cases, the handgun background check case and the take title to radioactive waste cases, Justice Amar, those were directed at the states. So, Justice Taha, the concern about interfering with federalism presented in New York and Prince is not presented by a law that bears directly on individuals, which is what Congress was authorized to do when the Commerce Clause was passed. But necessary and proper comes in to help us here, Justice Amar, if I could just go back to my premise at the beginning. My opponent does not dispute that Congress can make insurers sell insurance to people with pre-existing conditions, and not at rates that are higher than what they charge to other people. They concede that is within Congress's commerce power. It is necessary and proper to make that scheme work, that the people who would otherwise shirk health insurance, roll the dice, and shift their costs to others
But
be made to buy insurance too.
Couldn't Congress just as easily have told insurance companies, you can and indeed must charge higher rates to someone who has not had insurance for the preceding X number of years? Wouldn't that have the same effect as what they're doing now, except requiring people to enter a market before they choose to or before they're forced to?
Absolutely, but the commerce power does not mandate a socialist response, and it does not mandate an uncompassionate response. My opponent thinks that the commerce power can only be extended if you charge the person on the way to the hospital in the ambulance. I have the defibrillator here, but I won't use it unless you sign the insurance papers right here, right now. That is conceded to be a regulation of commerce, but Congress was entitled to decide that was inhumane, and charging people more.
But isn't it inhumane to charge a 20-year-old who doesn't have the money today, but may decide very rationally that in 10 years they will have the money, and in 10 years they will need the insurance, and they're willing to pay a higher premium if that was mandated, but they're not being forced at the age of 20 to enter a market that they don't really choose to?
Justice Science, there are many exceptions to the requirement for people with low income, people who are otherwise, if the income is not enough to sustain it, you don't have to pay. And those exceptions make it rational in just the way you described. Congress thought about that problem and tried to scale the obligation to take income and ability to pay into account. But just back to the necessary and proper clause for a moment. If you concede that Congress could make the insurers sell to people with pre-existing conditions at equal rates, then it is necessary and proper to that scheme, or as Gonzalez versus Raich, the concurring opinion, said, it is an essential part of a larger regulation of economic activity in which the regulatory scheme could be undercut unless the activity at issue were regulated.
Is there no liberty interest here that triggers something more than a mere rational relation test, which is pretty toothless?
And I don't think it's necessary in the ordinary use of the word necessary. In fact, there's been a couple of studies that suggest that we could do without the mandate and premiums would go up somewhat, but they wouldn't go through the roof. They'd go up maybe 15–20%. Is that too much?
Your Honor, I refer you again to the brief of the California Endowment, which describes the experience of states that tried it your way, the way you describe. And the experience of those states, Kentucky, Maine, New Hampshire, New Jersey, New York, Vermont, Washington, was that if you have guaranteed issuance and community rating, but you don't have mandatory coverage, you have what is many economists have described as a death spiral of increased insurance premiums and decreased insurance coverage.
Do we have to arbitrate between dueling economists on that question?
You don't.
I'm a little uncomfortable making a prediction about what will happen in that context when you have different experts who seem to have different views on that.
Your Honor, let me be clear on the standard of review and go back to Justice Moran's question. We do not suggest that mere rational basis review is what you're applying. As I said at the outset, we believe Congress needs to have shown you that it had a empirical demonstration of a tangible link to commerce. But it doesn't have to show that it has the only empirical demonstration. You don't need to decide the battle of the experts. All you need to decide is that Congress took valid empirical evidence into account, and it surely did. There's only one state that found a way to avoid the death spiral, and that was the state of Massachusetts, Romney Care, in which the addition of the minimum coverage requirement was what avoided the death spiral. Congress was entitled to take the empirical demonstration, not just of the economists, Your Honor, but of the experience of the states, the fundamental units that Justice Taha refers to, who have a police power over health care and insurance. And that experience is what taught Congress that what it did federally was the only way to make health care for all affordable for all.
But, Counselor, since you talk about the negative state experiences, and since this mandate appears to be a hybrid, it's either they purchase insurance or they pay a penalty, and you're talking about the interstate commerce clause and the responsibilities of Congress in this area. But there's a majority of states that are opposed to this mandate requirement. So if the state experiences have been so negative, why are a majority of states arguing against this mandate and saying that it's not constitutional and it's against their interests? And since we're also a new economic era, in your brief where you use the term an economic crisis to justify the need for this, if it is a correct need, but also at this new era economically where we have the internet, isn't the interstate commerce clause now applicable to everything we do in life? And isn't this perhaps an ultimate subversion of state rights and working against the entire intention of the Constitution?
May I answer?
You may answer in 1 minute that very easy question.
The Commerce Clause was enacted to prevent us from being a fractious and disunified and balkanized series of separate principalities. It was to unify us into a common market to solve our common problems. Healthcare affordable for all is a national problem. And the states have sent their representatives to Congress, and the people of the states have sent their representatives to Congress, and Congress has solved that national problem, not by infringing liberty. There's no liberty interest to avoid health insurance here. We've long since left the days of Lochner, where people had that sort of liberty interest. And you should uphold this law under the commerce power without getting to the taxing power, with the necessary and proper clause if you need to, but alternatively under the taxing power if you need. Thank you very much.
Thank you, counsel. I would ask our timekeeper to add a minute to opposing counsel's time as well. You may proceed, Mr. Boutros.
Madam Chief Justice, and may it please the Court, this case is not about the virtues of universal health care or the wisdom of enacting the Affordable Care Act. Rather, this case is about the structural constitutional limits on federal power which are necessary to safeguard individual liberty, notwithstanding what Ms. Sullivan said. As this Court has recognized, the powers delegated to the federal government are few and defined. The individual mandate is an unprecedented and unconstitutional expansion of federal power. For the first time in American history, the federal government is claiming the power to compel private citizens to engage in commerce by spending their own money for goods and services they do not want. Such intrusion into purely private economic decisions is a far cry from the limited and enumerated powers that our Constitution grants Congress. Indeed, it amounts to a wide-ranging police power, which the framers denied to the federal government and reserved to the state governments. It would mean that the federal government can compel a citizen to purchase any product or service it commands. This is not just some technicality or, as Petitioner's counsel suggested, a kabuki dance. This is enforcing constitutional mandates that the framers viewed as exceedingly important. And this is an important point, the federalism principles are meant not simply to protect the rights of the states, but to protect individual liberty and the liberty of citizens and the freedom of citizens. The framers wanted to diffuse power and decentralize power because they had experienced abuse of power when it was centralized in a king. And the federalist system goes right to that point. Although the government argues that the healthcare industry is unique, there is no stopping point. Ms. Sullivan offered no stopping point whatsoever, no coherent limiting principles whatsoever. If Congress is allowed to mandate that all Americans purchase health care insurance, there's no reason to think that this will be the last of such mandates, no reason at all. The same rationale would support a mandate that every American purchase more vegetables so that we're a more healthy nation, or that an American-made car be purchased by everyone to further an auto industry bailout. But the Commerce Clause only authorizes Congress to regulate commerce, not to create it or compel it. When an individual decides not to purchase health insurance, or as a lot of people do, they just don't do anything, they're not doing anything. They're not engaging in commerce. There's no commerce for Congress to regulate. And this court has never suggested that the power to regulate commerce includes the power to compel involuntary commercial transactions.
Counsel, can I? A lot seems to hinge on this activity-inactivity distinction. So let me just ask two questions. Could Congress tell people, look, if you don't have insurance, you might be contagious because you're not taking care of yourself, you're not going to a doctor. So if you don't have insurance, we're not going to force you to buy insurance, but you can't enter into any place of business where you might infect someone else. You can't drive on any roadway where you might get hurt, and we have to take care of you. Those would be regulating the activity of entering into a business or driving on a roadway. Would those laws be okay?
At least that would be regulating activity, Your Honor. And
if Congress can do that, what is gained by forcing them to craft a law that way that in practice does not leave any choice for anybody?
Well, first, Your Honor, it goes back to the structural components of our government. To say that Congress can mandate people and force people to buy products, to reach into someone's house and say, you've got to go spend $5,000 a year is a huge power, and it would...
But the Commerce Clause is already a huge power. Let me give to you another. What if Congress... Implicit in your argument is it's okay to prevent the insurance company from discriminating against people with pre-existing conditions, and that's essentially forcing transactions that insurance companies might otherwise decline to enter into. So let's restyle the law in anti-discrimination terms. You don't have to buy anything, but you can't discriminate against health insurance in your purchasing decisions. If you buy anything, first thing has to be health insurance. That's all regulating activity. If that satisfies your test, what is the game we're playing?
I think that's very different, Your Honor. Again, that's regulating at first the activity of the insurance companies, but with respect to the Commerce Clause, this isn't some technicality. The Commerce Clause gives Congress the power to regulate commerce. Regulate means to set the rules of the road. So setting the rules of the road for commerce that's occurring, for people who go into the insurance market is one thing, but to compel them in is completely different.
Well, following on Justice Amar's question, would Congress be right to do exactly what they're doing, but use the taxing power as opposed to the Commerce Clause or the necessary and proper clause?
Yes, I think Congress could have used the tax power.
So as opposing counsel pointed out early in her argument, before she backed out of that argument, she pointed out Congress could very well tax everybody in order to pay for health care and then give a credit for the equal amount of the penalty that they're doing now to the people who actually purchased health care.
Well, this court has recognized that one of the principal limiting factors against Congress exercising the tax power is the political difficulties of passing a tax. That's why this isn't a tax.
We've established that, but they could do it. They could do it exactly that way, and it would be constitutional.
Correct.
So what are we fighting over?
The Constitution, Your Honor. The Constitution is an enumerated...
But in practical terms, could if we were to rule that this has to be struck down, but the next Congress was to enact the exact same scheme in practice, but label it a tax, you would have no problem?
Your Honor, I think Congress would have that power to collect a tax, but the fact is...
With absolutely no change in practice or implementation.
You're still compelling people to buy a product or pay a penalty. You're just labeling it a tax.
No, you're taxing people and then defraying the increased cost from free riders through the tax.
They're economically equivalent, right?
And I assume, Counsel, you would have no problem if all 50 states, as Massachusetts did, passed a mandate that you have to obtain insurance and required pre-existing conditions, et cetera, to be covered, which you cannot afford without the individual mandate.
That's correct, Justice Gray. That would be consistent with federalism, with the people's rights to vote for laws that govern health and welfare.
As a practical matter, why should we have to wait for 50 states to individually act when the court could, in deference to the legislative branch, find a way to have the Affordable Care Act ruled constitutional? Because the system that is currently in place penalizes those of us who do have insurance, because we're paying for emergency rooms, we're paying for uncompensated care at hospitals, which there's a certain unfairness to that. So why can't the court find a result, either through the taxing power or the necessary clause or the commerce clause, to uphold this result, which you acknowledge could be upheld if they specifically cited the taxing power or all 50 states in the alternative passed it?
Your Honor, you mentioned from a practical standpoint, and yes, from a practical standpoint, it would be wonderful to have a better healthcare system, but the Constitution establishes a structure and rules and limited powers that go to something more fundamental, liberty and our structure of state governments. And yes, states could do it. That's what the Constitution anticipates.
What's the threat to the structure if you're saying they could have enacted the same scheme with the same practical implementation if they just labeled it tax instead of mandate? And is there an example where we have in the past said it's okay to implement the exact same scheme if the legislature will simply put a different label on it?
Remove the word penalty, and everywhere the word penalty appears, just say tax.
Well, yeah, I think it would still be just labeling a tax would not solve the problem.
Why is this not a tax if it was labeled? If it were labeled a tax, why is this not a tax?
It would still be a problem in terms of the taxing power, the way this is structured,
and why?
In terms of the mandate.
But all taxes are mandates. You don't pay. I mean, all taxes are imposed. So why? Again, if Congress affirmatively called it a tax, as my brother just asked, what would be the problem under the taxing power with that?
Your Honor, the framers did not grant Congress the power to tax people in order to compel them into transactions that can be taxed.
Well, aren't I compelled, I certainly felt compelled to buy a home by the magnitude of the deduction for a mortgage.
You were encouraged, Your Honor.
Well, how would that not be the same? How would this not be encouragement if it were labeled a tax instead of a mandate?
And collected by the IRS.
Yeah. Well, but again, as some of the members of the court were pointing out here, this is if anything, it's a fake penalty because there's no power for the IRS to really enforce it, to collect it.
Wait a second. Do we have to have a criminal code that throws tax breakers in jail to call it a tax? If Congress said we no longer want to put tax cheats in jail, but we rather want to have civil fines, it wouldn't make it any less of a tax.
Your Honor, here, President Obama made absolutely clear this was not a tax. Congress made clear this was not a tax.
How so?
By calling it a penalty and by not treating it like a tax.
Does the Constitution refer to taxes as only taxes? What words does the Constitution use when it refers to the concept of taxes?
This would be the first ever of its kind tax, and that brings me back to the novelty of this legislation. This court has made clear that where Congress acts in a way that it's never acted before, and everybody admits, Ms. Sullivan admitted, this never in the history of our country has Congress ever compelled private individuals to engage in economic transactions.
But she points out that the limiting principle, as I understand it, is that we already, Congress and the American public already are required to provide the health care that under this would be covered. So as I understand the limiting principle, what makes this unique is it's unlike life insurance and all the other things where we don't have to provide it.
You know, that is not a limiting principle that finds any place in the Constitution or emanates from anywhere in the Constitution. From a practical matter, that they're saying for now that's good enough. But it would give Congress an unbounded sweeping police power. Whenever Congress thinks we want to create jobs, it would be easier from a practical standpoint to just order everybody to buy products from American companies. That would create jobs.
Counsel, as I understand it, again, you've basically conceded that they could do exactly that if they labeled it a tax, like the tax relief for a home mortgage, rather than calling it a mandate. So if that's the case, if they could enact the exact same scheme but put a different label on it, then isn't the effect of what you're asking is that we have another Congress, a different Congress, revisit this issue And is that really something this court should be doing?
Absolutely, Your Honor. That's what the constitutional structure is all about. There are enumerated powers. Congress can't declare a war and then under the taxing power and then say, well, we meant to invoke the war power. That would be unconstitutional. These aren't little technicalities.
Is there a requirement in any of our cases that says that Congress has to identify the enumerated power on which it's acting? McCulloch versus Maryland, to me, the seminal case in this whole dispute, refers to all kinds of Article I powers that the government never cited in its briefs.
Well, Your Honor, here Congress made clear it was exercising the commerce power, that it was not enacting a tax. It couldn't enact a tax. The politicians knew they would get skewered if they tried to make this a tax, so they didn't do it. They used the commerce power.
Were the people unaware of the economic effect of the mandate? Did Congress hide the fact that you would be paying money to the Treasury if you didn't get insurance?
Well, it was clear that Congress was mandating that people engage in commercial transactions, and that there would be a penalty.
And if they didn't, they would pay money on their 1040 form.
But that would never be collected from them if they didn't pay it. So it's a toothless tiger.
Bottom line, should we be considering whether we believe the general public was fooled into thinking this is something other than a tax, even though it knew all of these implications for individuals through payments to the IRS?
No, Your Honor, that is completely irrelevant. And I want to go back, and Justice Moran, I think you had a question. I interrupted you.
Did, but I mean, mostly I wanted to ask you, the claim here is that there's inactivity and that we're essentially wrongly forcing people to engage in activity. And I just wanted to push on that a little bit, because isn't there here risk-creating activity? Because you know that by not purchasing health insurance, you are creating a risk to others that they will have to subsidize your health care. And so that's the relevant activity. And we know we use the tax code to incentivize some risk-taking activity. For instance, investment in capital markets is incentivized through a reduced tax rate. Why can't we also incentivize people to avoid negative risk-taking activity through this kind of tax scheme? It's a symmetric system, isn't it?
That's not the kind of activity this court has ever suggested would come within the ambit of the Commerce Clause. In, for example, the Morrison case, the Lopez case, let me use Lopez as an example, carrying a gun in a school, around a school, that's an activity, but this court precluded the kind of inference upon inference that carrying a gun could cause harm, which could cause costs, which would affect commerce. Morrison.
What about under the taxing power? As a regulatory activity under the taxing power, would it be permissible, if this in fact were a tax, for it to be used to incentivize people to avoid certain kinds of risk-taking behavior, that is, putting their access to health care at risk and forcing others to subsidize the costs of that risk-taking behavior?
Not as structured as a mandate, Your Honor. I don't think Congress...
Is it a mandate? You can go without. You just have to pay the penalty. That's a disincentive.
I think that's different than a tax, Your Honor. That a tax is you are assessed with a tax, you must pay it. Here, it's a penalty.
Why isn't it a tax on your decision to decline to purchase health care insurance, which is not forcing you to do it? It just says there's a tax attached to that decision. You can still go without it, you just pay the tax.
Your Honor, that is the classic definition of a penalty. It's meant to punish you, to encourage you, and to deter wrongful conduct. I think that's a penalty.
Let me ask you this question. Proceed with a little history. Actually, candidate then Senator Obama opposed an individual mandate. There was a famous debate with Senator Clinton. And it was only during the course of negotiations with members of the right as well as the health plans that the point was made, look, we can't afford covering everyone with pre-existing conditions. We can't afford to put limits on health insurance unless we have a bigger pool. And a pool, by definition, has healthy people, not so healthy, and unhealthy people. So if the court won't let America come to that conclusion, how do you suggest we come to that conclusion?
Your Honor, the court will allow America to come to that conclusion if the proper mechanisms are used. The public option,
what would that be?
The public option would have been a perfectly appropriate way to do this. Tax incentives for insurance companies to provide insurance in a way that would cover all people.
Counsel, doesn't Congress already force individuals to do activities that perhaps they don't want to do, whether it be the draft, jury service, pay their taxes? So aren't they already forcing action on individuals who don't want to take those actions?
Absolutely, Your Honor, but pursuant to explicit powers in the Constitution, the war power, necessary and proper, we have a draft. The key here is, and it is, I want to keep coming back to the point, this isn't some academic technical issue. These principles of federalism, the Commerce Clause, the limited powers of the federal government are exceedingly important to our freedom and our liberty and how we function as a country, and it was very important to the framers. That's why it's important how Congress sought to regulate here, and I think Justice Amar had made the point, the novelty of this. The Congressional Budget Office warned in 1990 that a mandate requiring all individuals to purchase health insurance would be an unprecedented form of federal action. And this court has noted, I'm paraphrasing this court, that if it takes 220 years for Congress to come up with a massive power that it's going to exercise, then maybe it doesn't have that power. They would have come up with it before.
But Counsel,
would have exercised
but conditions
it
change.
It was actually the Heritage Foundation
suggested
which introduced this idea of an individual mandate back in the debate in the early 90s about health care reform.
Occasionally they have good ideas.
Well, and as I say, one that then Senator Obama opposed, possibly for some of the same reasons you're articulating. But as a practical matter, we don't solve this problem unless we expand the pool.
And Counsel, I mean,
and I don't know that it's responsible of the court just to say, well, we're gonna opt for a triumph of process over substance, and Congress, you go figure it out, and just leave America in a patently unfair situation where most Americans pay far more for health care than they should have to, while some Americans' only form of health care is the emergency room.
Well, I appreciate your honor. I know the court wants to do the right thing, but there are limits to what the court can do, and that's Congress is the branch that must make those political decisions and enact the laws pursuant to the Constitution.
What is the liberty interest here? I mean, why is this a fundamental liberty interest that we should be protecting?
Well, Your Honor, it would give Congress a sweeping power to command people in their private lives to engage in private transactions.
Why can't we limit this to the extraordinary situation that Petitioner has described, where there is a huge impact on the American economy, where there is clear interdependency, and where we know, predictably, that people will underestimate their need for health insurance, and there will be free rider problems, there will be adverse selection. These are very unique circumstances that involve a market in risk and insurance. So it's not so clear to me why the slope is so slippery.
Well, I accept all of that, Your Honor, and that these are important issues that need to be addressed. But there's a right way and a wrong way under our Constitution. And the liberty interest is, without the protection of specific provisions, with Congress going farther than it's ever gone before, it is a real risk. It would give Congress a power it's never had before. Congress could tell people to engage in transactions.
But Counselor, Petitioner said the Lochner era is dead. Why are you resuscitating it for us today?
Liberty is not dead. Freedom is not dead.
But economic liberty, Petitioner said, was rejected, and the rational relation test applies, and we have many more forms of discretion to regulate economic activity than other kinds of liberty activity, right, reproductive interests and so on. So why isn't your argument one that echoes in Lochner, and why should we give credence to it?
Two things, Your Honor. One, I think the government is vastly overestimating the degree to which individual economic liberty is dead. And I think that's number one. Number two, this is a penalty. When there's a penalty involved, that creates other concerns. When the government is first commanding people to do something and then threatening to punish them for that when they don't do what the government told them to do. And third, with respect to why this is a liberty interest to begin with,
concede that it is an economic liberty interest?
Well, I think it's more than that, because it's not only it's causing private individuals to have to take action in a way that's it's not just spending money, but it's
purchase insurance, which is an economic activity. So why is this not an economic liberty interest? Why is it something more?
Well, I think the structural protection against unbounded congressional authority goes beyond mere economic liberty.
With individual liberty as at issue, do you have any problem or issue with the Massachusetts health care plan?
That as Governor Romney has made clear, that was an issue for the state of Massachusetts to decide.
If the states were promoting this kind of health care plan, you find that or feel that was constitutional?
That would be up to the states. And Your Honor, that goes to the point that, and I think Justice Moran was pointing me in this direction, that the liberty I'm talking about isn't the sort of specific moment-to-moment liberty. It's the protection against the power of the federal government going beyond being able to intrude at any moment into someone's life. And that's
Counsel, can I choose not to pay for Medicare? I'm 45. I don't know when I'll be eligible for Medicare. They keep pushing out the eligibility date. Could I just say, you know what, I'm tired of this. I'm going to stop paying Medicare.
Or Social Security, because frankly, I'd like to self-fund my own retirement.
Those are all laws that were passed pursuant to the taxing power and other powers that Congress has, and there's no dispute about that. That's the problem here. You can't have the Congress of the United States violating the constitutional rules that are absolutely
Okay, well,
clear.
Counsel, you mentioned other powers, so I want to hear what your response to Ms. Sullivan's invocation of necessary and proper is.
Absolutely.
Because, as I understand it, it's a pretty straightforward argument that once you tell insurance companies they can't discriminate on the basis of pre-existing conditions, if not the only way to make that work, at least a sensible way to make that work is to require people to be in the insurance pool. So why is this not fit comfortably within the reasoning of the concurrence in Raich or the majority opinion in Comstock, which I got to say is even broader? That's the case involving involuntary civil commitment. Those people were being confined for not doing anything, but for being sexual deviants. And yet the court, we held that falls within necessary and proper.
Yeah, two things. I think I heard Ms. Sullivan say that there were several other ways to accomplish this.
But McCulloch says necessary does not mean absolutely necessary, but rather helpful, appropriate. I mean, if you want us to revisit the interpretation of the word necessary in the necessary and proper clause, that's a big step. But necessary in McCulloch and then again in Comstock and Scalia's concurrence in Raich means appropriate, helpful.
Well, Your Honor, McCulloch is a good example because there Chief Justice Marshall said 200 years ago that the action that's taken under the guise of the necessary and proper clause has to be constitutional. It has to be constitutionally valid on its own. Congress can't create a scheme, create a bunch of problems that by way of a regulatory scheme and then say the only way out is to do something unconstitutional as part of the same regime. That does not comport with the Constitution.
In Comstock, the problem was created by the federal government having incarcerated these folks who at the end of their sentence may be deviant and the states weren't going to take care of them, so the federal government had to step in and commit them. But it was a problem of the federal government's own making, and we had no problem with that.
You could make the same argument in Raich that it's the government's enforcement of the Controlled Substance Act. If it wasn't illegal, you wouldn't have the problem with.
Right. That's why we're worried about it leaching into the market, because we've made it a black market.
Well, in both those instances, but just take Raich, there was activity there. We were not talking about going to someone who wasn't growing and smoking in marijuana and telling them to do something else. There was activity occurring, and so I think coming back.
No activity in Comstock. You were detaining people because of sexual deviance. They were just being.
Well, sexual deviance is, I think, a form of activity, and that would justify.
It was a propensity.
Based on other activities.
Isn't it a status, Counselor? Isn't that a status rather than an activity for people who are detained?
I think, Your Honor, the status was based on an assessment of prior activities, which would take it out of the context of this case.
And what if I was to assert to you that every human being has a propensity to get sick and need health care?
Breathe.
And therefore, it would be the exact same situation.
That wouldn't
feeling so good myself right now.
that takes us right back to for example, the Morrison case. There, the Violence Against Women Act, exceedingly important policy to create a civil action for women who are victims of domestic violence. Domestic violence causes significant costs. Reducing domestic violence would reduce costs, and that would affect interstate commerce. The Supreme Court said whatever Congress said in findings, we're not going to look at that. This court said that's for us to decide, and we're not going to pile these inferences upon inferences upon inferences to connect it to interstate commerce.
And that leads me to the question. I believe I heard Ms. Sullivan say they do not wish to invoke any rational basis test anywhere here. If that's the case, what is the test you would argue for?
Here, I think it's a legal test as to whether compelling a person to engage in private economic transactions they wouldn't have engaged in, it constitutes the regulation of commerce. The answer, based on the history of our country, the meaning of the word regulate, is no.
So does that require some perfect alignment with between the purposes that Congress has and the fix that they put in?
No, Your Honor. I think the court, this is a pure legal issue. The plain language of the Constitution says regulate commerce. To command someone to engage to get into commerce, to reach into a house where someone's doing absolutely nothing, they're watching television, they've never even thought of health care in their life, and say, you go spend $5,000 for health care, that's not regulation, that's commanding, that's mandating. The Constitution, the Commerce Clause, does not permit that. So I don't think this is a rational basis test. I don't think let me add to the fact that the California Endowment's brief is excellent. But for these purposes, it's irrelevant for my argument. It doesn't matter the debates, the policy debates. Justice Gray was making some excellent points about the need to fix the system. And the court's impulses may be, we've got to help Congress out here, but you can't do that.
So when the Constitution says that Congress has the power to regulate the land and naval forces, that means Congress can't force people to do things even if they're just sitting there?
Well,
regulate does not include the power to mandate?
Well, the land exists, Your Honor, and the armed forces exist.
Right, so Congress is given the power to regulate the forces. That does not include the power to tell them what to do?
Yes, Your Honor, once they exist, but before, if there weren't
a separate power that says they can raise and support armies.
Exactly.
Yeah, but there's a distinct
That's my point.
No, there's a distinct power that says they get to regulate them.
That's my point, Your Honor.
But the word regulate includes compulsion.
But you've made my point, Justice Amar. The Constitution explicitly distinguishes between raising an army and regulating it, creating money and regulating the value of coin. The Constitution does exactly that. That's our point. Here, Commerce Clause doesn't say create commerce and then regulate it. It just says regulate commerce. You don't regulate something that doesn't exist. And that's my point.
Counsel, albeit through the taxing power, Congress forces us to contribute to Social Security, then decides the only way it's going to invest the surplus, I think we still technically have a surplus, is through treasuries, which obviously over the last 2 or 3 decades was not the best way to maximize those, to grow that money, and then uses whatever surplus it has to fund general fund programs. I mean, is that not a more onerous mandate than the ACA?
It's certainly created some problems, Your Honor, that's for sure. But at least it's consistent. All I'm here doing is saying, here's what the Constitution says, here's what the framers meant. And if Congress makes decisions that don't work out so well and they properly exercise their power, that's a different question. But what I'm saying, our position is that the Commerce Clause is very clear. Congress did not exercise the tax power. It sought to invoke and heretofore never exercised power, and that's beyond the scope of the powers that the framers of the Constitution gave them. Yes, Your Honor.
Since Massachusetts is our only real model to look at, was there a substantive constitutional challenge on the state constitution in Massachusetts to its constitutionality as well as to the federal constitution?
I don't believe so, Your Honor. But again, it's a very different situation where the people of a state enact a law. The states are traditionally vested with this power over the health and welfare of their citizens. The federal government was not supposed to have that police power, so it's a really different question.
Does Massachusetts model have a penalty in it?
I believe it does.
Counselor, if I might just add one, if you had someone who had purchased insurance, health insurance, and wanted to drop out of the market, you would permit Congress to compel that person to remain in the market in contrast to someone who had not yet entered the market and did not wish to enter the market that year?
May I answer, Your Honor?
You may, very quickly.
Your Honor, I think that would be a closer call because that person has entered commerce. That person is in commerce, and therefore Congress would have a much better case for regulating.
Liberty would no longer apply. You could become perpetually conscripted to purchase health insurance once you entered the market. And wouldn't that in turn deter people from entering the market, thus worsening the problem that Congress is trying to solve?
That goes to the point I was making earlier. It's not simply economic liberty in the act. It's the broader concept of liberty in a system that has limited powers in the federal government.
Madam Chief Justice, I just have to ask, going off what Justice Moran said, haven't we all entered the market? If a child is born their parents may pay for it, but if they're born in a hospital, haven't they entered that market already? And aren't they then all exactly the same as what Justice Moran described?
Many consumers have, but many haven't, and many of them have done absolutely nothing to enter commerce, and it would be unconstitutional to force them to do so. Thank you.
Thank you, counsel. We will hear rebuttal.
Three quick points: slippery slope, standard of review, novelty. Now, my friend and opponent says if Congress can compel the purchase of health insurance, there's no limit. Congress could compel the purchase of life insurance or flood insurance, but that's not so. The Chief Justice expressed exactly the government's limiting principle. Mr. Boutros said the government has no limiting principle. We do. And the limiting principle is the compulsion of the purchase of insurance an essential part of the rest of the scheme where the services have to be offered.
Well, the Chief Justice is not altogether sure that's a limiting principle, because it seems to me that we are still left with the question of a negative activity. And when you go to the definitions in all of our cases, there's got to be something happening.
What's happening is I'm imposing the risk of my uncompensated care on someone else. And as Justice Moran described earlier, that is an activity. I am imposing the risk of my uncompensated care on someone else if I don't buy insurance. Now, the difference from flood insurance and life insurance is if a person has a flood and doesn't buy insurance, Justice Farrar, they can't compel the carpenter to rebuild their house for free. And if a person dies without life insurance, they can't compel the gravedigger to bury them for free, or their children can't compel the grocer to sell them groceries for free. But a person without health insurance can go to the hospital under the Emergency Medical Treatment Act and compel the delivery of services for which they have not paid.
But Congress could revoke that act and say, as uncompassionate as it may be, Congress has the power to say we're not going to force hospitals to treat people who don't have insurance. That may not be the solution, but they have that power. The question here is, do they have the power to do what they're doing here?
They do, because what they're doing here, whether it's regulating an activity or not, is an essential part of another regulation that's conceitedly of commercial activity, and that is the sale of health insurance to people with pre-existing conditions and the delivery of health care services. So they could do otherwise, but now that gets me to the standard of review, Your Honor. They need not have a perfect fit or a perfect alignment between purpose and means. My learned opponent seems to be arguing for strict scrutiny. Congress can't do anything unless it shows a perfect fit. All it needs to show is an empirical demonstration of a tangible link to Congress. And it has more than done that by reference to the state's...
Empirical demonstration of a tangible link. Where does that come from? Have we used that?
Your Honor, it comes from your opinion, Justice Kennedy, in the concurrence in Comstock. In Comstock, as you rightly said, and back to Justice Farrar's question, Congress can cure a problem even of its own creation. That's what Comstock said Congress was allowed to do in civilly committing sexually dangerous criminals who'd previously been incarcerated.
Counsel, Congress's power from Article 1 is enumerated.
Correct.
Certainly expanded, but enumerated. Okay. And we have the 10th Amendment, which reserves to the states and to the people anything that hasn't been given to Congress as a power in Article 1. Where do we get to the point where individuals who have no duty to act are being penalized for failing to act? Because typically omissions are punished when there's a duty and a breach of the duty to act.
Well, Congress here is not punishing, it's taxing. But let's not get into that debate again.
So now we're back on its attacks.
But let me go back to, my opponent conceded that Massachusetts could permissibly impose this obligation. And once he conceded that, Your Honor, he conceded away any liberty interest, because neither the states nor the federal government can violate a liberty interest. And once that liberty interest is gone, all that's at stake is the power of Congress.
But doesn't that question lead to that if the states took the lead, if the Massachusetts model is so good that other states would replicate it and let the states do as they should do and take care of their people?
Your Honor, where there are market failures, the framers found that the states would not take care of things. Hamilton wrote that the states would not take care of a common defense. They would leave it to Maine to police the Canadian border. And the states won't take care of free rider problems that cross state lines either.
The states were laboratories. Isn't that where we're supposed to experiment to make things work, not at the national level?
But, Your Honor, federalism works both ways. When Congress has seen that the laboratories of the state have proved an experiment has failed, it's entitled not to repeat their error. The experience of every state but Massachusetts shows that mandatory health care insurance provision cannot work without mandatory health insurance purchases. Allowed to be means tested, allowed to have exceptions for the poor, allowed to have an alternative that you don't have to buy it if you pay your taxes. You should uphold the law and reverse the decision below.
Why have not other states moved in that direction?
Quickly.
I'm sorry, Your Honor, I didn't hear the question.
Why have other states not moved in that direction then?
Well, Your Honor, there are many states who would like to move in that direction that can't. Congress sometimes steps in when the political will at the local level can't solve a problem that the nation can solve. Congress solved it. It was within its constitutional power to do so, and you should find the act constitutional. Thank you.
Thank you, counsel. Thank you, counsel. The case will stand submitted, and we will return in due course. I want to take the privilege on behalf of the panel and of the law schools involved here tonight of thanking the California Endowment for sponsoring this and inviting our students, and also to say what a privilege it has been to serve with this distinguished panel. Thank you all very much.
If law school's this entertaining, I really missed out. Let's go right into some questions from members of our audience, including Peter Hong, former Los Angeles Times writer, now in the LA County Office. Supervisor Mark Ridley Thomas asks, how, if at all, can the legal rationale for state auto insurance mandates, which of course exist in California, apply to this case? Petitioner Sullivan, Ms. Sullivan?
If I understand the question, it's if the state can compel you to get auto insurance, why isn't this constitutional? Well, my opponent would say that because the states are freer than the federal government to impose individual mandates. I think that's what concedes away any liberty interest when it comes to buying insurance. That is indeed, I think, as Justice Moran said, just an economic decision. It's not protected against interference like contraception or abortion decisions. So I think that proves the liberty point. It doesn't prove the federalism point because, of course, the argument here is that Congress can't do everything the states can.
And I would add that...
I was going to say that I think that there's also one distinction, and that is that nobody is compelled to drive. If you choose to drive, then you have to abide by the regulations, which include insurance, driver's license, things like that. The health care bill, you're basically required to get health care for breathing. So you're not really involved in a specific activity where you choose to subject yourself to the regulation.
Although you could argue as a practical matter in a place like Southern California with certain types of jobs, you pretty much do have to.
Same with Miami.
Yeah. Justice Moreno, did you want to? Yes.
Yeah, I mean, it's the regulation of driving and automobiles and insurance are all typical state-regulated activities, and there's activity, as my brethren pointed out. So it's a typical police power activity.
And this clear constitutional distinction between the two. Everybody agrees. Okay.
Let me just add,
yes.
as a practical matter, the states that have tried to adopt health care insurance in their states run up against the economics of the health plans, who say the economics do not work, the policies will be too expensive, they'll be prohibitive unless you require everyone to participate. So whichever way we turn, we get back to the individual mandate, which again was proposed by the Heritage Foundation on the right, and does call for individual responsibility. I know when I was young, I'd like to postpone things I was supposed to do as long as I could. It's just human nature. So no one's going to get health insurance when they're young and feeling immortal unless they're required to do it. If they don't get health insurance, we cannot in turn ensure that pre-existing conditions don't exclude you from health insurance. So,
all right.
You know.
Justice Davis, thank you. This question comes from William Marbury, whose affiliation is taxpayer, and that's as important as any. It says, in order to prepare for a flu pandemic or bioterrorist attack, could Congress mandate that all citizens vaccinate themselves in order to protect national security? Which one of you would like to weigh in on that?
Well, interestingly, in a case called Massachusetts against Jacobson, the court already held that a state may compel vaccination as part of the traditional police powers that Justice Moreno was referring to. It's not yet been raised before the court whether Congress could do the same. But in terms of a liberty interest, the answer is yes. And so if the follow-on is, can you make people take care of themselves so that they don't get sick, it's kind of on a continuum.
And I think it would come under the enumerated power of common defense under the U.S. Constitution.
All right, Justice Moreno. Nancy Gomez of Health Access says, I understand that the ACA arguments before the Supreme Court will not be televised or otherwise made public. I think sometimes they do audio releases, don't they, after the fact?
They do same-day release right after.
Same-day release, okay. Why? And is there anything that consumers or advocates can do to make the case available in real time?
I'll be pleased to answer that one. The Supreme Court has now gone to audios. One of my big passions is access to courts, and I think it would be fantastic if the court were to allow televised arguments. The California Supreme Court does, as Justice Moreno well knows. Many of our federal appellate courts do. In the Proposition 8 case, which I'm involved in, we wanted the trial to be televised and videos to come out so that people could see the arguments. This was a great panel, by the way, so it was fantastic. And seeing the interaction with the lawyers is a huge benefit. The Senate is now considering legislation. There have been pushes. The justices, I think, many of them are resistant. I think some of the newer ones are less resistant. So I'm hoping that they're wonderful to watch, all 9 of them, and it would be great for America. So I think if everyone keeps pushing, someday it's going to happen, and someday soon. I think it would be great.
I just wanted to say that I think the debate over cameras in the courtroom has transcended the Supreme Court. The pro side is we want transparency, we want the public to be educated about what goes on in the courts. The flip side is a concern that the justices will start to play to the cameras, that the cameras will distort the dialogue in the court in a way that a mere audio tape won't. If you're interested in hearing those audios, they are posted on the web at Oye, 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 which also has descriptions of the cases. So there are opportunities to find out what's going on in the court and learn. And I have to say, having listened to some of those tapes, they're very illuminating. And there's also a transcript that goes with them so you can tell which justice is talking in case you don't know what their voices sound like. But I don't think it's a straightforward issue. There's been a lot of debate about the impact of cameras on the gravitas, the dignity, and sort of the integrity of the judicial process.
Well, and I would think there'd be few people who would argue it would not change in some way because it's human nature. We do certain things when we're on camera or make one, but the question is, would that change justice? Would the outcomes be different by having the cameras? Justice Ferrer, you're on TV every day, so what do you think?
I think that if we can't count on the Supreme Court justices not to play up to the cameras, we're in a lot of trouble. But our courtrooms are open to the public. We don't have star chamber justice in this country where doors get closed and you don't know what happens behind. Anybody can walk into a courtroom with very limited exceptions, national security and certain circumstances, can walk into a courtroom and watch a trial. And putting a camera in the courtroom really only makes that gallery that's limited seating unlimited. So people at home can watch the same thing as if they'd gone down to the courthouse.
But I know you're doing a television show, so it's a little different. It's a production. But do you really think, comparing when you were on the bench versus if you're doing something in front of a camera, that it really has no effect on the behavior of jurists?
It depends on the judge. I'll tell you, I handled a lot of very high-profile cases. It's actually how I ended up on TV. Some producers saw video of me handling cases and thought that I might do it well on television, but it depends on the judge. Some judges take it in stride, and lawyers have appeared in front of judges in high-profile cases and have seen the judge just handles it normally, and same with lawyers. It's really the judge's obligation to keep the lawyers in check and not let the personalities go out the window. But there are some judges, none that come to mind.
I'm sure.
Right.
Justice Davis, yes.
Courts are very familiar with the concept of balancing the equities. And even if certain justices might be inclined to play to the camera, you have the right of the public to know what's going on. I think illuminating, as distinguished counsel Boutrous indicated, the illuminating experience of watching 9 justices, all of whom have compelling attributes, make their arguments. And so it's not just would the justice be somewhat uncomfortable or maybe act slightly out of character, but basically would the entire process benefit from more transparency.
What do you get from the video you don't get from the audio in terms of the substance?
Well, you don't get it in real time, first of all.
But if you broadcast the audio in real time, would it be necessary to do
Well, it's
video?
better than not real time.
Right.
Well, I would argue one thing that you would get is nuances. There's certain things from hand gestures to facial expressions, body language that I think could be very telling that you don't get on the audio. Plus, it's more difficult to follow the audio if you're not really familiar with the voices of the justices. That makes it much more difficult than if you're seeing them.
Just to close the loop, the Judicial Conference of the United States has some pilot projects going. I think the points made here are that it is possible that there may be some changes. They're going to look at these questions, and these are very thoughtfully done pilot projects.
Just real quickly, how many of you think it would be good to do real-time telecasting of Supreme Court hearings? How many of you think would be a good thing to do? This is pretty split. Okay, maybe 60-40%. Yeah.
I just have to say, I'm intrigued by the possibility of enticing some of these justices away from the court to television, as happened with.
Thank you, Justice.
I'm interested.
Who is your agent? They'll be contacted. Okay, this is from Stephen Jones of the Law Office of Stephen P. Jones. If Congress can't require persons to purchase coverage, isn't it impossible to contain costs effectively without either one, imposing further health care taxes or deny health care to the uninsured?
I think that's a really good question, and it goes to the policy question, and Justice Gray, we'll keep calling you Justice for the rest of the night, and then I'll made this point. But I think there are other mechanisms. The public option that was considered, that I think President Obama pushed for during the campaign, at least, and there are other ways to do it, but taxes are a proper way to do it, but it's hard to get support for more taxes. So I do think there are other ways to do it. And my arguments on the Commerce Clause, I mean, I support these notions of getting broad health care, but here I think there's a real question. It's a very difficult question whether Congress used the right mechanism as a constitutional matter.
And I may be opening a can of worms by asking this, so hopefully I'm not walking into a 5-minute answer. But this came up, the issue of the difference between the tax and a penalty, and how you mentioned the framers of the Constitution had a certain approach, constraining powers, whatever the intent is. Can you just quickly elaborate? So why, if the net effect, as the justices were asking you, is de facto the same, why does the nomenclature matter and have some sort of deeper resonance or precedent that's set?
Absolutely. The Supreme Court has said that one of the biggest restraints on Congress using the taxing power too much is that taxes are unpopular. If you hear your taxes are going up, you can get upset, and it's going to come right out of your pocket. If you read in the paper that Congress is invoking the Commerce Clause, it's not that big a deal. It's easier to get that through. And so I think as a constitutional matter, the Supreme Court has noted that fact, and that's why the court should not, I think, relabel something that I think was pretty clearly done under the Commerce Clause as a tax, because that's a dangerous precedent too.
Except that, I agree with much of that analysis, except that, of course, in this day and age, we get told in the public discourse that things are raising your taxes when they have absolutely no connection whatsoever to taxes. So it comes up in public discourse regardless of what is really being debated in Congress.
Fernando, and I'm sorry if I mispronounced the last name, whether it's Untra, I believe, USC Law School. If the court invalidates the ACA or even parts of it, would that not be the imposition of a particular economic philosophy, call it liberalism, he says, on the whole population, such as in the Lochner case?
No, it's a very nice question. I think what we've demonstrated today is in part a debate about health care and in part a debate about separation of powers. Will the court, as the court did in defiance of the New Deal measures passed by Congress under President Roosevelt, try to throw out something that was passed through a very delicate political process on the ground that Congress didn't do enough homework, didn't have a good enough empirical demonstration, didn't look to the right state experiments and so forth. That's a very audacious thing for the judicial branch to do, to stand up to the elected branches acting united in a rare moment when they acted with unity. And I think the court will be very cautious before it does that. I think that's why the standard of review, the sort of technical debate we were having about the standard of review, is really also a very practical debate. How much deference should the court give the political branches out of respect for the people and the will of the people, as opposed to the unelected will of the court? And so there is a danger here that if the court were to throw out the product of the elected branches, even if some people don't think it's a very good product, would that be the court asserting a role for itself that would make it illegitimate? When the court tried to do that with the New Deal, it took another 40 years for it to make up the damage it did to itself, and it may seem somewhat audacious. Again, that said, we've now had an era in which we've revived the notion of federalism and we've put limits on Congress, and that's why I tried to argue the case for the government, starting from the premise that Congress had to have a pretty good reason. It had to have a tangible link to commerce. It had to have an empirical demonstration. It couldn't just wave its hands and say, oh, you know, the house that Jack built, the hip bone's connected to the thigh bone and the thigh bone's connected to the knee bone, and it will all work out if you pile inference upon inference. So I think that's at the heart of the debate here, as well as the debate about health care, is, well, what's the court's role in a democracy, and will it stand up to the elected branch? And I think there are very powerful arguments on both sides here, and I've actually had the privilege of doing a moot court on arguing both positions. I think both sides are powerful here, but in the end, the tiebreaker may be deference to the political branches.
This is from one of the members of our audience, didn't share a name, but regarding the requirement that hospitals provide emergency medical care even if someone is uninsured or doesn't have the means to pay, this is requiring a business and its employers to provide a service. So if government can require the provision of a service, why can't it require individuals to buy an insurance to cover that service?
That is, again, an excellent question. There are really, I think, two reasons. One, the hospitals are in commerce. They're engaged in commerce. They're making money. They're providing services. So they've already entered commerce. Secondly, they're also getting funding from the federal government, and therefore, as a condition of that funding, Congress and the federal government have more power over them, those commercial actors, to require them to provide those services.
And finally, I don't think it's come up so far this evening. We're only taking up one provision of the Affordable Care Act, but the justices of the U.S. Supreme Court could come down with several different decisions, and part of the ACA could be invalidated, other parts not. And wonder, could someone just elaborate a bit on that? We have an audience question about what happens if part of it is thrown out. Does the whole thing collapse? Who would like to elaborate on that?
Well,
Justice Kessler.
Yeah, I mean, the justices are free to declare the mandate unconstitutional, but sever it from the rest of the statute. There is a debate as to whether or not they would be allowed to do that, but I think they're free to do that, and that is a potential compromise position that they might adopt. Another compromise position, another issue that's involved here is whether they can reach the constitutionality of the tax issue, whether that issue is right because no one has paid the quote-unquote tax yet, and that's another compromise position that they could adopt. They could say, well, we need to wait till 2014 until someone actually pays one of these penalties to consider whether or not it's constitutional.
You folks all live, eat, breathe the law. How many of you are particularly excited about 13 days from today, what's going to start? How many? You all are into this, would you say, or not so much? Yeah?
It'll be very interesting to see what they say.
Yeah. All right. I want to thank you all so much, our justices and our advocates. On behalf of the California Endowment and the co-sponsors of this evening, thank you for joining us for the California Endowment Moot Court event. For highlights of the event, you can go to the Cal Endowment website. Have a great evening.